Live.
Good evening, ladies and gentlemen. On behalf of the Federalist Society Student Division and the Boston University School of Law Federalist Society Chapter, welcome to tonight's Feddie Night Frights. My name is Liam Edward Cronin, and I serve as the president of the Federalist Society Chapter here at Boston University. Today, I have the honor of introducing our topic and our distinguished referee for this evening. Our topic tonight is Return of the Living Constitution. This is the third year in a row that Professor Eric Siegel and Professor Ilan Wurman have faced off in a Feddie Night Frights event, the annual Halloween rebranding of the Federalist Society's Feddie Night Fights. Our referee for this evening is Judge Lawrence Vandyke. Judge Vandyke serves as a circuit judge on the United States Court of Appeals for the Ninth Circuit. Prior to his appointment in January 2020, he served as Assistant Attorney General in the Environment and Natural Resources Division of the Department of Justice, and before that served as Solicitor General of Nevada and Montana. At the beginning of his legal career, he worked as an attorney at Gibson, Dunn & Crutcher. Judge Vandyke received his law degree magna cum laude from the Harvard Law School, where he was an editor on the Harvard Law Review. After graduating, he served as judicial clerk to Judge Janice Rogers Brown of the United States Court of Appeals for the DC Circuit. And with that, I will hand things over to Judge Vandyke to further explain tonight's topic and introduce our fighters. Thank you.
Well, thank you, Liam, for your kind introduction and for the opportunity to once again do this for the third time. Well, here we are again, ladies and gentlemen. In 2020, right in the middle of the pandemic, we had our first Halloween match between Professors Wurman and Siegel about originalism and constitutional interpretation. It was a doozy. I think if I remember right, both men were carried off the field, and a lot of us wondered whether either one would survive. But the thing was, we all wanted to have more, and they both survived. And so 1 year ago, we had the long-awaited grudge match, same topic. And once again, it didn't disappoint. After about an hour and a half of back and forth, I think what happened, if I remember, was the FCC pulled the plug on the program because, among other things, they concluded it was just too traumatizing for children and, by extension, law students. But that only left our fan base, which by this point was quite considerable, clamoring for more. So by popular demand, we're back, this time bigger and badder than ever. It's basically the same topic we've had the last 2 years, Return of the Living Constitution, question mark. And we couldn't have picked a better year for this rematch. We've had some massive decisions since last year's debate, Dobbs, Kennedy, and Brom, just to name three, which I'm sure will be discussed at length tonight between our two panelists. And while I'm sure that for many in the audience tonight, our two rabble-rousing professors need no introduction, I'm going to give one short one anyway, because that's basically my only role in this event. Heaven knows that nobody could possibly moderate either of these two professors. So starting with Professor Siegel, Eric is a chaired professor at the Georgia State College of Law. He teaches all the good courses like con law and federal courts. His articles have been published in the top law reviews. He's written several books, including with titles that are very relevant to our topic tonight, Originalism as Faith and Supreme Myths, Why the Supreme Court is Not a Court and its Justices are Not Judges. And Eric has a podcast called Supreme Myths. Professor Worman is an associate professor at the Sandra Day O'Connor College of Law at Arizona State University. And he also teaches cool courses like administrative law and constitutional law. He also writes on administrative law, separation of powers, and constitutionalism. And his academic writing has appeared in all of the cool law journals also. And he is the author of several books that also have titles that are very fitting for tonight's debate: A Debt Against the Living, an Introduction to Originalism, and the Second Founding, an Introduction to the 14th Amendment. I don't know whether Ilan has a podcast or not, but you can see we have a pretty even matchup between our two professors. But what makes it perhaps most interesting is that after our first grueling matchup 2 years ago, Ilan started CrossFit. Coincidence? Ilan insists that it was, but the rumor on the street is that Ilan was taken aback by Eric's intense physicality in that first matchup. And true story, shortly after last year's grudge match, I started CrossFit, which I'm not ashamed to admit was precisely because I was impressed by Ilan's increased athleticism between his first and second year. I was hoping that maybe it would help me in my role as a judge on the Ninth Circuit for some of our, and all I ended up doing was injuring myself. But interestingly, Eric was very unimpressed by all of this and has refused to jump on the bandwagon. Indeed, just to prove how unimpressed and unintimidated he is, Eric recently gave up his lifelong sport of tennis, sending the unmistakable message to Ilan that he feels that he can dominate this debate on sheer intellect alone. Bold move for sure, but we'll have to see if that strategy works out. So with that background, let's get this party started. Here's the rules of tonight's match. I think it's the opposite of last year. This year, Eric's going to start, followed by Ilan, and then we'll have a rebuttal from Eric, followed by Ilan's rebuttal, and then after that, we'll do some Q&A. I just want to let the audience know you'll have two options to submit your questions. You can either use the Q&A function in Zoom to write up a question, which I'll be able to see and ask, or you can raise your hand using that function in Zoom to queue up to ask a question, and I just might call on you. All righty, time to ring the bell. Eric, take us away.
Thank you, Your Honor. It is great to be back with you and with Ilan. I want to thank the Federalist Society for having me back. I'm actually always amazed when the Federalist Society asks me to come back. I view that as kind of a badge of honor, and I'm really, really happy to be here. So I guess the title of this talk, of this debate, is Return of Living Constitutionalism ? My thesis throughout the debate will be from roughly 1857 until 808 on 10/26 October tonight. We've only had living constitutionalism. That's all we've ever had. That is all we're ever going to have until we dramatically change the structure of the United States Supreme Court as an institution. So first, I'm going to give a very general reason why that is. Then I'm going to talk about last term to show how it was living constitutionalism on steroids. And then I'm going to explain historically why this is the case. The Supreme Court of the United States is a unique institution in all of world history. There are other legislatures and congresses and parliaments, and there are other presidents and executives, and there are other Supreme Courts, but there is no Supreme Court like ours. And a perfect storm of factors have made living constitutionalism the only possible way for the Supreme Court to interpret this document. We have the oldest written constitution in the world governing a country. The oldest written constitution is actually that of Massachusetts, but that only governs a state. The United States Constitution is the oldest governing constitution in world history. It is also unbelievably hard to amend. It takes supermajorities in both Congress and the states, which explains why since 1791, there have been exactly 17 amendments after the Bill of Rights were added. It's unbelievably hard to amend. We also have an institution staffed by judges with life tenure. It is the only Supreme Court in the world that has that, except maybe Iceland, but I don't think they do very much. And we have a long tradition of aggressive judicial review dating back to the time when the Supreme Court said to Congress in 1857, no, you cannot end slavery in the territories, even though the clear text of the Constitution allows you to make all rules and regulations for the territories. So that's the 30,000-foot picture. If you have an institution like that with all of those structures in place, living constitutionalism, and by that I'm just going to say for this purpose for tonight, ideology, not law, is going to make the difference. So we can see this in last term. And the irony of the most originalist court in Supreme Court history having one of the most living constitutionalist terms in Supreme Court history is quite something if you really reflect on that for a minute. So the state of Maine decided that because of its rural nature, it had to help fund students attending public schools and private non-religious schools in very rural areas. They decided to do that, but not extend the same financing to children who attended religious schools. And they said they had establishment clause concerns about doing that. The Supreme Court said to Maine, no, you can't do that, Maine, citing the free exercise clause. Not a word of history was mentioned because there is no history relevant to that decision. The text obviously is ambiguous and doesn't matter. So the court took away Maine's right to structure its educational policy based on nothing but ideology. Also last term, a school district in the state of Washington told a high school football coach, no, you're not allowed to pray at the 50-yard line. When you are responsible for students, they're still in his care. They haven't gone back to the locker room and gone home. And they warned him, they said, you can go off in a corner someplace and pray, but no, you can't pray with students around you, and you can't pray in the 50-yard line right after the game. There are all kinds of establishment clause reasons why that might be the case. And the Supreme Court said to that school district, no, you can't punish him for that. Again, no history cited at all, none, zero, nada. And the court just made that up, that school district couldn't do that. The Bruin case, ironically, is the most living constitutionalist case I've ever read in all my time of constitutional law. Because in this case, the justices said that states and cities and towns and the federal government aren't allowed to take public safety concerns into effect when making gun regulations and gun laws. That all judges have to look at when deciding gun cases is whether a similar law was around in 1789 or 1868. That is inconsistent with everything we know about constitutional law and originalism. The founding fathers absolutely understood that rights could be limited and abridged if the public policy interest was strong enough. 99.6% of constitutional law, maybe 100%, is the Supreme Court balancing the asserted right against a public policy interest that's being advocated to limit that right. That's constitutional law. In the Bruin gun case, the court said, no, you can't do that anymore. All of that is off the table. That has never happened before in American history. And it is as aggressive and wrong and ideological as any decision I've ever read. And it's just plainly wrong. It's not how the constitutional law is supposed to work. Those are three cases. The EPA versus West Virginia, the West Virginia versus EPA case, where the court made up a fantasy major questions doctrine to limit the ability of Congress to delegate power to the president, has no historical or textual precedent. Ilan's going to argue there is historical precedent for that. We can't get into the weeds tonight, but he's wrong. But in any event, the major questions doctrine does not appear in the text of the Constitution. It's not a thing. They just made it up. And then finally, I agree that the Dobbs decision did reverse 50 years of living constitutionalist decisions. And the Dobbs decision on its face is not a living constitutionalist decision, but we expect the judges under the rule of law to be bound by text, history, tradition, and precedent, and to reverse 50 years of precedent for no other reason than the people on the court changed, as Justice Kagan argued in dissent, and as she has said in public statements since, not identifying Dobbs by name, but we all know what she means, when she said that people are going to start wondering if this court is really a court, if they reverse like 50 years of precedent for no reason than the people on the court changed. So in that sense, it was very much an aggressive living constitution type of decision. That is just obviously the tip of the iceberg. That's the most originalist court in history doing those five things. The reality is text, history, tradition, and precedent have never, ever been important, even in a minimal way, to how the Supreme Court reaches decisions. They are important to how the Supreme Court explains decisions, but that's a problem because that's a huge transparency gap. So let's talk about this. Nothing makes me madder than when people say text matters, because text doesn't matter. It's never mattered to the Supreme Court of the United States. And there are a lot of reasons for that. First of all, in most litigated cases, the text will be way too unclear, imprecise, and ambiguous to do any work. We all agree on freedom of speech. We all agree on no establishment of religion. We all agree on the free exercise of religion. We all agree no cruel and unusual punishments, no searches and seizures that are unreasonable. We all agree with due process and equal protection. What we disagree about is applying those vague aspirations, which we all love, to new and changing fact patterns over time. Text doesn't help any of those cases. There's not a single free speech case, with the exception of maybe the Pentagon Papers case, which involved a prior restraint, and maybe Citizens United, which also involved a prior restraint, which, by the way, was correctly decided, despite what most liberals say, that where the words free speech helped us decide the case. Now, I am not saying that text is irrelevant to constitutional law. I'm not saying that. We have to have a 35-year-old president, and the only reason that Wyoming gets the same number of senators as California, Texas, and New York is because that's what the Constitution says very clearly. But those provisions don't get litigated. That's not part of constitutional litigation. It's part of constitutional law, and those are very different things. Text doesn't matter. Here are just some representative examples of so many I could give. There is no anti-commandeering clause, full stop, doesn't exist, it's not there. There is no dormant commerce clause, full stop, it's not there. There is no sovereign immunity clause that bars states from being sued by their own citizens. In fact, the sovereign immunity clause says exactly the opposite, that a state can't be sued by a citizen of another state to which the Supreme Court has said that means the same state. There is no major questions clause, okay? All of those major limits and major constitutional doctrines are made up and are not in the text of the Constitution. Here are some rights that we all have that are fundamental, that are not in the text of the Constitution. We have the right to travel from state to state, not in the Constitution. Adults have the right to refuse unwanted medical treatment if they're competent, not in the Constitution. We have the right to raise our kids as we see fit, not in the Constitution. We have the right to send our kids to private school, not in the Constitution. We have a right to contraception, so far, not in the Constitution. We have a right to same-sex marriage, not in the Constitution. I could go, I'm sorry, marriage is a fundamental right, not in the Constitution. I could go on and on and on, and all of that is why constitutional law legends like Akil Lamar and Lawrence Tribe write books that are called things like the Unwritten Constitution or the Invisible Constitution. But very seriously, Jonathan Guinnap, a historian at Stanford, is now making the case, and he's right, because I've done the research myself, that the founding fathers, if we care about that kind of thing, and I'm assuming everyone here cares about that kind of thing, the founding fathers absolutely did not understand the Constitution as the beginning, middle, and end of what the Constitution means. To them, there were customs and natural law and all these other things. And the Constitution was just a small part of what is constitutional law. I do not believe that's a debatable historical point. And Jonathan said he made that point in his first book, but his second book, which will be out next year, makes that point emphatically. So text doesn't limit the justice's decisions. It never has. And in fact, when it comes to the 11th Amendment, they've done exactly the opposite of what the text says. All right, so we're throwing text out the window. Can't work, doesn't help. I can't spend too much time on history because I'm limited to 20 minutes, plus we've had this debate twice in a row. To almost all modern constitutional litigation, history is either irrelevant. It doesn't matter whether muskets could be taken in sensitive places because assault rifles are not muskets. They're just not. So usually it's irrelevant. Usually it's unknowable. If it is unknowable, it's normally contested. But most importantly, as I've made the argument 2 years in a row now, I'm going to quote Ilan Wurman, who wrote one of the smartest things I've ever read. Ilan wrote in his book, and this book was meant to be, and Ilan can correct me if I'm wrong, an introduction to the concept of originalism. He is defining originalism in his book, which I reviewed and thought was quite good. And he wrote, and I quote, "Originalists recognize that original meaning often requires that the application of the text evolve, I'm going to say it 3 times, evolve, as modern circumstances evolve. I'm going to say it again, evolve, evolve, evolve. What Ilan calls originalism is in fact living constitutionalism. It just is. And I can talk more about that later because that's one of my favorite topics. But Ilan might think he's an originalist, but if he believes that so for example, we know the 14th Amendment, we know this for certainty, was not meant to protect women, which is why the Supreme Court said Illinois could bar women from being lawyers in the 19th century, and why in the 1940s, the Supreme Court said that Michigan could bar women from being bartenders. And it wasn't until the 1970s when the Supreme Court finally decided that strict scrutiny minus or heightened scrutiny applies to women. That's because applications change, as Ilan said, as modern circumstances evolve. We don't care about constitutional meaning. We care about applying constitutional provisions to new and changing facts when we're talking about litigation. When we're talking about the fact that Wyoming gets 2 senators, then we care about meaning. But when we talk about litigation, we're talking applications. And Ilan just told you, I just told you, Ilan said, that applications change as circumstances evolve, living constitutionalism. All right, that's history. I'm just going to mention tradition briefly. Tradition is the dumbest thing of all. Scalia should never have talked about it. Here's my proof to you that tradition is absolutely no constraint. We know with 98% certainty that next June, the Supreme Court is going to end affirmative action and require colorblindness in university admissions across thousands of colleges and universities. This country has never had a second of colorblindness. We went from slavery to black codes to segregation to Richard Nixon putting pressure on Harvard, Yale, and Michigan to admit more black students. We have never, not for 1 second in this country's history, had a colorblind government in any way, shape, or form. And when the Supreme Court mandates that next June, not only is there no tradition of that, there is the anti-tradition. It's been exactly the opposite forever. Tradition doesn't matter. Which leads me to precedent. Because if text, history, and tradition don't matter, at least maybe we have precedent. And of course, many people think it is that part of the rule of law that distinguishes judges from other political actors. Precedent has never mattered to the Supreme Court and does not matter now. And if you don't believe me, you can ask Sam Alito. Because in the second most important footnote in Supreme Court history, the footnote 48 in Dobbs, Justice Alito was trying to justify the overruling not just of Roe, but of Casey and 50 years of precedent. And so he dropped the footnote saying, here are all the, in his words, here is a partial list. That's a direct quote. Partial list of important cases where we reversed ourselves. That partial list is 2.5 pages, single space. And it covers virtually every area of constitutional law. First, second, fourth, fifth, sixth, eighth, 10th, 11th amendments. All of them. They've all changed dramatically over time for no other reason than the people on the court changed. Now, some people might say, oh, I'm just talking about the Warren Court versus the Roberts Court and whatever. No, I'm not. So I want to kind of end my argument that it's always been living constitutionalism on steroids by mentioning a few things. In 1935, of course, President Roosevelt went on the radio, threatened the court, 1936, threatened the court and said, we have aged and infirm men on the court because they were striking down his New Deal programs. Huge moment of time in American history. Bush versus Gore was a huge moment in 2000, where if Al Gore had taken a different direction, we may have a very different situation today. But I'm going to go back much farther than those things. I'm going back to 1870, and I'm going to end with this fable, which tells us that the controversy we're in today is not new at all. It's been with us from the very beginning. The Constitution only mentions coin. Congress did not print paper money until the Civil War. And Congress did that, obviously, because it needed money to fight the war. They print paper money. When the war is over, there's hyperinflation. These new greenbacks aren't worth very much. And creditors wanted to be paid back, not with greenbacks, dollars, but with gold or silver. So one creditor was paid back with greenbacks, dollars, and sued. Case went all the way to the Supreme Court. Now, this is 1870. A law professor writing in 1935, 65 years later, said between 1789 and 1935, the most watched case in Supreme Court history, including Dred Scott, was this legal tender case. It was the most watched case, the most talked about case, the most debated case. And if you think about it, I'm not an economist, but it's an obviously of incredible importance where the Congress make paper money legal tender. And in a partisan decision, the Democrats who were representing the upper classes at the time held Congress did not have the power to make paper money legal tender for prior debts. Huge decision. And this decision, they didn't say we reversed McCulloch versus Maryland. It effectively reversed McCulloch versus Maryland and the concept of implied powers and broad authority under the necessary and proper clause. The day the decision was announced, ironically, President Grant, Republican, had two picks. And listen to these words. Everybody knew there was a litmus test. In 1870, there was a litmus test. President Grant would only appoint justices who would reverse this landmark, huge case. So he appoints two new justices. 1 year later, 1 year, the court reverses itself only because of those two new justices. And the dissent in the first case, which was really long, becomes the majority opinion in the second case. And the majority opinion in the first case becomes the dissenting opinion in the second case. It's all partisan politics. And here's the key. The newspapers in 1871 that didn't like the opinion accused Grant of stacking the court, of putting his cronies on the court, of doing nothing but manipulating the court against the rule of law to achieve the result that the Republican Party wanted to achieve. And there was as much publicity by the standards of the day of those two cases as anything that happened last term. From Dred Scott to the civil rights cases, to Lochner plus 200, to robust free speech doctrine, to the Warren Court's excesses. I believe Reynolds versus Sims was wrongly decided. There's nothing in the Constitution about one person, one vote. It's not there, and you can't find it there. To Roe, to not Citizens United, which was correctly decided, but all the other cases, to Shelby County, and then to Bruin last term. The only thing the court does in high-profile constitutional law cases is living constitutionalism. Even Heller is a living constitutionalist case for reasons we can debate later. And if Judge Vandyke or Ilan or Eric Siegel were on the Supreme Court of the United States, and we had to interpret an ancient document that can't be amended with life tenure and a long tradition of aggressive judicial review, we would do what we think is best, all things considered decisions, as long as we thought the American people would go along with it. And that description is exactly how the Supreme Court has acted from Dred Scott through the Bruin case last June. Thank you very much.
Thank you, Eric. Controversial and powerful as always, but I'm worried that Ilan may not be able to find anything to disagree with in all of that. But I do think he kind of threw you and me and himself under the bus there at the end. So do something to protect our honor.
Sure. Well, thank you so much for having me on this debate for a third year in a row. And I have to say that it is always a real pleasure to have this discussion with Eric, because I learned so much from him. So it is really not just a pleasure, but to all of our profit, like to listen to him. Not many people engage in good faith the way he does. I'll preface my remarks by saying that the sort of 15 to 20 minutes that I prepared is not going to be directly responsive to a lot of the specific things he said, like about anti-commandeering, dormant commerce clause, sovereign immunity, all the rights he talks about. There is actually textual original support for all of those things. I hope I will get to it maybe in my 10 minutes after. But don't take it as a concession that I do not respond to specific points that he mentioned. So on this topic, the return of the living Constitution, where I kind of want to take us is, I think it's true what Eric says, that for much of American, or partly true, in the sense that for much of American history, judges were in fact living constitutionalists, at least in some cases. But it was only in a small part of time, a small span of time, roughly the 1930s until about the last decade or so, that they were openly living constitutionalists, and in most cases. And I want to suggest that for the periods in which at least the court was purporting to be originalist, originalism at least gives us a standard by which to judge the court's decisions. If they were openly living constitutionalists, which they weren't, which shows that originalism has always somewhat been part of the law, right? But if they had been, I should say, openly living constitutionalists, and we had acquiesced in the proposition that living constitutionalism is an acceptable way to do judging, then quite frankly, we have no standard to judge them, except by the consequences of their decision, which of course is no standard at all, because those in power will always believe that their political views lead to superior consequences, which I take to be Eric's point. At least originalism is a more objective standard. I do think Eric's going to disagree with me about that, but I do think it's a more objective standard, even if an imperfect one. A purportedly originalist court will not always lead to genuinely originalist outcomes. But as they say, hypocrisy is the tribute that vice pays to virtue. At least we know what virtue is with an originalist standard at hand. Okay, so I guess with that background in mind, I'd like to make two arguments. First, the eras in which the court was occasionally being living constitutionalist were on the whole pretty terrible to the extent they were being living constitutionalist. And not merely because they got the original meaning wrong, but precisely because the original meaning of the Constitution would have in fact led to superior consequences, at least by our modern sensibilities. So even if we want consequences to be our guide, originalism always would have led to far better consequences. Okay. Second, and fast forwarding to the present, I do want to argue that the Supreme Court, once again, I don't want to appear to be agreeing too much with Eric, but once again is not being fully originalist. I agree with that, but at least it's being more originalist. And part of the reason, by the way, it isn't being more originalist is because the litigants aren't briefing the cases, right, in a fully originalist way. So I don't want to be too hard on the modern court. I do think if more litigants briefed things in an even more originalist way, then the court would more fully embrace it. And I think the results would be maybe less reliably conservative, okay? At least once again, originalism would give it this standard by which to judge them. Okay, so let's go back in time. Eric started 1857. I thought he would say more about it, so I was prepared to talk more about 1857. So I'm just going to talk about 1857. Okay. The court in Dred Scott was pretending to be originalist, but was in fact being living constitutionalist. But Dred Scott was decided in 1857. So the question in Dred Scott was whether free Black persons were citizens of the United States within the meaning of the Constitution. Now, there's no question that Taney was purporting to be originalist, but he was in fact adopting the prejudices of his time. And more to the point, I think, originalism refutes Taney's entire decision. Here's what Taney said. It is too clear for dispute that the enslaved African race were not intended to be included and formed no part of the people who framed and adopted the Declaration of Independence or the Constitution. For if the language as understood in that day would embrace them, the conduct of the distinguished men who framed the Declaration would have been utterly and flagrantly inconsistent with the principles they asserted. The African race had for more than a century been regarded as beings of an inferior order, altogether unfit to associate with the right race in either social or political relations, and so far inferior that they had no rights which the white man was bound to respect. That's Taney, okay? That's Taney purporting to say the founders thought these things, and we're bound by the founders. However enlightened we might be today, that's what Taney said. However enlightened today we might be, the founders, they did not include Black Americans, okay, within the meaning of the Constitution, within the meaning of citizenship. Let me unpack this. First, was Taney right about the founders? Was Taney right about the founders? Well, here's Jefferson in his notes on the state of Virginia, query 18. The whole commerce between master and slave is the most unremitting despotism. I tremble for my country when I reflect that God is just, that his justice cannot sleep forever. I think a change already perceptible since the origin of the present revolution. The spirit of the master is abating, that of the slave rising from the dust, his condition mollifying, the way I hope preparing under the auspices of heaven for a total emancipation. Here's George Washington in a letter to Robert Morris from 1786. There's not a man living who wishes more sincerely than I to see a plan adopted for the abolition of slavery, but there is only one proper and effectual mode by which it can be accomplished, that is by legislative authority. Of course, John Adams, we all know he needs no defending. He, quote, held the practice of slavery in abhorrence and thought that every measure of prudence therefore ought to be assumed for the eventual total extirpation of slavery. In the US, that's a letter to Robert Evans in 1819. Of course, Benjamin Franklin, who also needs no defense, said because enslaved persons were men, by the laws of God and nature, they were capable of acquiring liberty. Alexander Hamilton, that was Alexander Hamilton in 1795. Ben Franklin said slavery was an atrocious debasement of human nature. James Madison in the convention, we have seen the mere distinction of color made in the most enlightened period of time a ground of the most oppressive dominion ever exercised by man over man. Okay, he repeatedly said that in the convention, but don't take their word for it. Take the words of the Southerners themselves. Here is Senator Robert Hunter in 1860, senator from Virginia, He said on the floor of the United States Senate, words to these effect. Okay, they were reported the next day, but confirmed to be largely accurate by his fellow senator from Virginia. We in Virginia have changed our ground. We do not stand where we stood anciently. We do not stand where our fathers stood upon the slavery question. We do not believe in what Washington believed, and Jefferson believed, and Madison believed, and Monroe believed, and all the leading men of Virginia for the first 50 years of our existence under the Constitution believed. We have changed our opinions in Virginia. And instead of now admitting that slavery is an evil to be restricted and discouraged, and which we may hope and pray may someday entirely be removed from the Republic, we now take the ground, now today in 1860, we now take the ground that it is a blessing to be fostered, encouraged, and extended as a benefit to the Black man and a benefit to the white. This, of course, was the positive good theory of slavery, first posited by the likes of John C. Calhoun and George Fitzhugh in the 1830s, 40s, and 50s. This was not the founders' theory. This was the theory of, dare I say, what was then a modern day social movement. And I say social movement because that's the buzzword criterion justifying constitutional change, according to living constitutionalists today. Well, so we know Tawney was wrong about the framers themselves and their intent. We know that Tawney was adopting the prejudices of his own time. But how do we know that he was in fact wrong about the Constitution? Well, originalism. And specifically, Justice Benjamin Curtis's dissent, which totally and utterly obliterated Tawney's argument using originalist and textualist reasonings as follows. Curtis first explained that free Black persons were citizens of at least 5 states when the Constitution was adopted. They were part of the community, therefore, that adopted the Constitution. The Constitution took them as it found them, right? Nothing in the Constitution strips them of their citizenship. There's no, Black persons who ratified this Constitution are no longer citizens clause, right? Okay. Now, Congress has a naturalization power. This is the power to make new citizens, not to take away citizenship. And then the natural born citizenship requirement for president implies that persons born here of citizens continue to be citizens. Dare I say QED? The descendants of those who were free Black citizens of the United States at the time of the Constitution's adoption are therefore citizens of the United States today. Originalism is what tells us that Tawney was adopting the prejudices of his time, that Tawney, under the guise of originalism, was in fact being a living constitutionalist. At least there's an argument for saying you can't just do that. Okay? If we, the people today, if we, the enlightened classes, believe that slavery is now a positive good, if we believe in living constitutionalism, who's to say, no, that's wrong, right? If they have a majority on the Supreme Court, they have a majority on the Supreme Court. At least originalism gives us a standard by which to judge them. Okay. Moving on in time, I don't want to belabor this point, but I think everyone agrees that a more living constitutional Supreme Court, okay, of course, when I say more, they were largely originalist. It's just in key places they weren't. The Supreme Court effectively eviscerated Reconstruction. Okay, in the slaughterhouse cases, the civil rights cases, Plessy against Ferguson, everyone, liberal, conservative, doesn't matter. Eric and I think, agree that the Privileges or Immunities Clause must mean something, okay? And almost everyone thinks that it means at least citizens must be treated equally, okay, with respect to contract, property, guns, speech rights, and the like. You can't have a black code, which is what they were targeting. But the court wrote the Privileges or Immunities Clause out of the Constitution and Slaughterhouse. I think more or less everyone agrees that protection of the laws was an affirmative duty of the government to protect individuals from private violence like the KKK. So Cruikshank and part of the civil rights cases were probably wrong. And of course, a law that treats Blacks and whites differently in basic civil rights, like in common carriers, as in Plessy, was understood by everyone in the 39th Congress to be the quintessential thing that was forbidden by the 14th Amendment. Okay, how could the Supreme Court have gotten all of this so wrong so soon after Reconstruction? Well, because I think they were adopting the prejudices of their time, not of the drafters and the ratifiers of the amendment, okay, for the same reason that Reconstruction ended in 1876, okay, racial fatigue. The court got things wrong in 1873 and 1883 and 1896. They could not imagine, okay, that the framers of the 14th Amendment would have been so enlightened when it came to the African race, just as Tawney could not imagine that the framers of 1787 could possibly have disagreed with Tawney's own views, okay? Here's Justice Bradley, who dissented in Slaughterhouse, to be sure, but was all on board in the civil rights cases. He wrote in his private letter as follows. Surely Congress cannot guarantee to the colored people admission to every place of gathering and amusement. To deprive white people of the right of choosing their own company would be to introduce another kind of slavery. Surely a white lady cannot be enforced by congressional enactment to admit colored persons to her ball or assembly or dinner party. Does freedom of the blacks require the slavery of the whites? An enforced fellowship would be that. End quote. Well, of course, we know that access to common carriers and public accommodations was understood by the leading drafters and all the supporters of the amendment to be covered by its terms because public privileges and public accommodations and common carriers were understood to be basic civil rights, not just your private dinner party in your living room. The Supreme Court justices were imposing their own cultural and social views, irrespective of what the Constitution had to say on the matter. Okay. Let me now say one thing about the Lochner era and judicial protection for contract and property rights. These cases depend on what due process means. And I'm going to spend some time on this because the modern cases also depend on what due process means. Now, most originalists, I think, accept, and I don't want to get in trouble. I know there are some dissenting views. Okay, so if Randy Barnett or Evan Burnick, if you're listening, I know I got it. Okay. Most originalists, however, accept that due process of law really is about process. Okay, the government can, the way it's written, the government can take away life, liberty, or property so long as there's due process of law. What is due process of law? First, it means that there must be law that's violated, right? The executive can't just throw someone in jail for violating no known and existing law. So the legislature must establish the law, and one's violation of that law must be adjudicated, at least according to the processes established in advance by law. The executive and the courts don't get to just make up process as they go along. Substantive due process is this idea that there are unwritten substantive limits on the law itself, on the law that can be enacted by the legislature. I'll just say that there's very little evidence for this view, although, as I said, prominent originalists do support it. They argue that law, to be law, has to meet certain substantive criteria to legitimately be law. Now, there's some evidence for this, okay? But I'm mostly with Blackstone and Law and Fuller, that law to be law just has to be publicly promulgated, it has to be knowable, it has to be prospective, and so on. These are largely procedural criteria, not substantive criteria. There is some evidence that maybe law had to be general and not special, but almost every case cited for that proposition, I've looked into this, I talk about it in my second founding book. Almost every such case involves the legislature trying to abrogate judicial procedure in a pending case or in a class of cases. So I think the evidence is pretty weak. Okay. On the assumption, just work with me, that there's little evidence for substantive due process, why did the court create this doctrine in the 1880s through the early 20th century? Well, probably because they were adopting the laissez-faire prejudices of their time. Okay, now I say prejudices, we all know that laissez-faire is actually mostly right as an economic and political theory. Okay, but the point is that that doesn't make it constitutionally required. Okay, as I think it was Holmes, I think in dissent said, right, the Constitution does not enact Herbert Spencer's social statics. Okay, Herbert Spencer's social statics is not, by the way, laissez-faire constitutionalism. You get the point, or laissez-faire, but you get the point. Again, how do we know that they were wrong, if in fact they were? Okay. Again, the answer is originalism, because you look at the history and the text, and you quickly come to realize that due process of law is basically procedural. Living constitutionalism can't tell you that. Okay, now let's fast forward to today, what you've all been waiting for. Most of the court's hot button cases last terms, Dobbs, Bruin, the two free exercise cases, were, wait for it, substantive due process cases. The court did not overturn substantive due process. It simply said, if we're going to do substantive due process, then we're going to have to limit it to those rights deeply rooted in American history and tradition, and we have to define those rights narrowly. Now, the result in Dobbs might very well be consistent with originalism if it had been decided under the Privileges or Immunities Clause. Okay? But the point is, the court didn't even ask the question. Okay, now, to be fair, the litigants didn't even brief it. So maybe they're to blame, okay? Maybe it's the litigants to blame. My larger point here, as I wrap up, is that if substantive due process is the route that the court is going to take, then I do agree with Eric that same-sex marriage and other cases are in trouble, right? Under the Glucksberg substantive due process framework, right? Under that framework, the right has to be narrowly defined. And the court asks if that right as narrowly defined is deeply rooted in American history and tradition. I think this framework, this question has the potential to allow a conservative majority to define rights in a way that always leads to the outcomes that their intuition tells them is right. Okay, because how narrowly you define the right, what history and tradition you look at, it starts to look more manipulative. But if the court were to go the route of privileges or immunities, I think Obergefell, the same-sex marriage case, at least has a shot. Why? Okay, well, as I've argued in my book, The Second Founding, okay, and another scholarship, the Privileges or Immunities Clause, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Okay, I think, and I know some people disagree with me, but they're wrong and they're not here. The clause gives the states wide leeway to define and regulate rights, all rights, contract, property, guns, speech, press, religion, as long as they don't abridge those rights by discriminating in their provision. Okay, now to be clear, maybe the clause does fundamental rights work too, but it at least does this equality work. Well, how do we know what is a genuine regulation of a right and what is an abridgment or discrimination in that right? Okay, I don't have time to go into this and I'm running out of time. Let me just say that the answer is simply whether the regulation is reasonably related to the purpose of the right. This is actually quite a simple question, but it's a very powerful question. Okay? This is why the black codes were so obviously unconstitutional. Why? Because skin color has absolutely no relevance to why we have contract law or property law. It's simply irrelevant, which is why a law saying black people can't own property is an abridgment, because it's not defining property rights, because it has nothing to do with property. It has nothing to do with why we have that right. Now think of a gay code instead of a black code, a code that says gays can't own property or can't enter into contracts. It's equally and as obviously unconstitutional, and I don't have to decide that being gay is a suspect class. Why not? Because sexual orientation obviously has nothing to do with property rights. Okay? But what about limiting marriage to one man and one woman? Is that regulating the content of the right of marriage or an abridgment by discriminating in the provision of that right? Now, this is a harder case because everyone knows that sexuality has something to do with marriage. But as I argue in my book, again, The Second Founding, gays can equally participate in most of the purposes of marriage and can participate almost equally, if not equally, in childbearing and child rearing. And by the way, if you sprinkle in a little no-fault divorce, okay, that makes that purpose even less important for straight couples. It starts to look like an abridgment to deny gays the right to marry. Okay, is this a foolproof case? No, of course not. But is it clearly wrong? No. And to overturn Obergefell under the conservative theory of precedent, I think it would have to be clearly wrong for them to overturn it. Okay, at least if you take Justice Thomas's injunction seriously. Real quick, since Eric mentioned the free exercise cases, at least let me mention this to make the point too. How would those cases come out under this analysis? Well, if you're giving funding for reading, writing, and arithmetic, simply refusing that money because someone also gets religious instruction seems to be relatively arbitrary. It seems unrelated to why you're giving out the funding for reading, writing, and arithmetic. So that strikes me as probably an abridgment. So I think that case would come out the same, probably. But I think the Coach Kennedy case would actually probably come out differently. It's plausible to think that limiting inspirational talks at midfield, right, to secular talks is related to the purpose of the right of giving talks at midfield, right? What might be the legitimate purpose here? Well, some students might feel coerced, and we don't want that. Okay, that's a totally plausible analysis, right? So under the originalist reading, it's the state could go further and require more separation of church and state than the court seems to say is required under the Establishment Clause. Okay, so I want to leave you with the following thought. If you are a liberal or a progressive, you should stop lamenting the rise of an originalist court. And you should stop claiming that the court is being living constitutionalist, or at least you shouldn't stop with that claim. You should want the court to be more originalist. And so you should brief originalist arguments, including under the Privileges or Immunities Clause. If you do so, you never know. You might be surprised by the results.
All right. Well, thank you, Ilan. So Eric, I assume he won you over and that you have nothing to say in response.
Well, I have a big point. First of all, I also learn from Ilan every time we talk. So, and I've learned things tonight. So I appreciate that. I have a big point and then about 8 minutes of small points. But my big point is thank you, Ilan, because if I heard you correctly, Dred Scott was living constitutionalist. The civil rights cases in 1883, I think it was, don't hold me to that, was living constitutionalist. The utter destruction of the Reconstruction Amendments from their known purposes of helping the enslaved people become equal to helping railroads and businesses make more money was living constitutionalist. The entire Lochner era was mostly living constitutionalist. The Warren Court was obviously living constitutionalist. So The question for tonight's debate was the return of living constitutionalism ? I think you made the case for me. We, in fact, have had a living constitutionalist court forever under the terms of your own presentation. Now, you might say we're only talking about the most important cases. In all the other cases, they were originalist. But two things about that. A, no, that's wrong. But more importantly, we define the Supreme Court by the cases that define us. Abortion, affirmative action, campaign finance reform, guns, equal protection, all that stuff. We don't define the court by ERISA cases. We don't define the court by cases we don't care about. We define the court by Plessy and Dred Scott and Lochner and Citizens United and Bakke and all those cases. So I believe by your own account, you have shown that in fact, we've always had a living constitutionalist court. Now, about Dred Scott, you're just wrong. Mark Graber, who I think is the leading expert in the universe on the Dred Scott case and a progressive liberal, has said, Professor Graber, University of Maryland, has said many times, it was a really close case under originalist, textualist type methodology. It could have come out either way. Then progressives get really mad at him and say, what are you talking about? How could it come out either way? He says, I'm just telling you what the law was. It's a close call. So you should be arguing with him, not me on that issue, but he is the leading expert in the universe on that case. You said that originalism would give us a standard to use, and you've just went through an entire 20-minute presentation of how it's been screwed up in every era, except for maybe from 1936 to 1954. You've just told us they've screwed it up all the time. That's because originalism cannot work with the type of legal materials we have. I have two more points. There is no originalist argument for free speech doctrine. Zero, none, the null set. And in fact, I believe you conceded this in one of our two prior debates. And I think you conceded in one of our two prior debates that the First Amendment doesn't bind Georgia at all, or Tennessee, or Mississippi, or Nevada. So Nevada could have all kinds of bars on free speech. And as long as they treat their own citizens the same way as other citizens, those laws would be valid. The founding fathers thought that prior restraints were illegal and wrong. The founding fathers expected and thought, and the meaning was clear, punishment after the fact for speech was allowed. The Alien and Sedition Act showed that. It's just clear. So everything we know about free speech is non-originalist. Judd Campbell wrote that article in Yale. He was right. He's a very serious historian. So if we adopt originalism and not what you call, I think, the prejudices of our day, if we adopt originalism, there is no free speech in America. That in fact, the state of Georgia could pass a law tomorrow saying every newspaper sold in this state must clear its op-eds with us before they publish them. This applies to in-state newspapers and out-of-state newspapers. Under your reading of the Constitution, I believe that's a valid law, because there is no originalist argument against that. There just isn't. As long as it's not a prior, it could be punished after the fact. The prior restraint wouldn't be allowed. Consequences is all we have. It's all we've ever had. And you know what? That's what Oliver Wendell Holmes said. That's what Richard Posner said. By the way, Richard Posner was no liberal. That's what William Brennan said. That's what Mark Tushnet has said. That's what the greatest legal Holmes, Posner, Brennan. These aren't insubstantial people. I haven't even got to Jeremy Waldron and others. Consequences is all we've ever had, because if you had life tenure in imprecise text and unknowable, contestable, or irrelevant history, you and I and the Honorable Lawrence Vandyke would do what we think is best, all things considered, if we thought we could get away with it. And I really want to make one last major point, and it's a big point. And this is the historical research I really have done. In 1790, and nothing about 1868 changes this. In fact, it might make it stronger. The idea of judicial review was what Hamilton said it was in Federalist number 78. There has to be an irreconcilable variance between a statute and the Constitution before judges should strike it down. He also used the phrase manifest tenor, same thing. I have read the state court cases at the time. I have read the people who wrote about this issue at the time, and everybody agreed that judicial review was going to be applied modestly, with humility, in a limited fashion, and only when there is clear constitutional error. That mega standard for the practice of judicial review has not been the governing law in this country since 1857, since Dred Scott. Justice Scalia voted to strike down over 140 laws in his career. None of them, zero, none, were at an irreconcilable variance with the United States Constitution. None of them. So the bottom line on this is, if you are an originalist and you believe history matters, these days a lot of originalists don't think history matters. We can have that crazy debate if we want. I know you think history matters, but many originalists don't. But if you think history matters, then our entire practice of judicial review is wrong. So if that's the kind of originalist world you want, we're best friends, because that's the rule I want. My normative values, my modern day preferences, as you would call them, is for the Supreme Court to almost never do anything in constitutional law in cases outside the 4th through 8th Amendments. They get to decide double jeopardy. They get to decide self-incrimination. They get to decide unreasonable searches and seizures, because judges run the courtrooms. That's what they know. They're experts. No one else knows it better. But they don't get to decide abortion, affirmative action, the balance between free speech and corporate dominance of our elections, and 50 other issues that so-called originalists have struck down. And you are quite incorrect, last point, about the Maine case. Their reason for not funding the parents or giving the parents of children in religious schools money was all wrapped up in the Establishment Clause, which the originalists on the court have deleted from the Constitution. Last term was the most anti-originalist, anti-textualist term since 1973, because I think Roe is wildly anti-originalist, anti-textualist. But last term, with 5 originalists on the court, all they did was living constitutionalism. And when they mandate color blindness next June for the entire country, for thousands of colleges and universities, all that is living constitutionalism. It was there yesterday, it's here today, and it's going to be here tomorrow, unless we dramatically change the structure of the United States Supreme Court.
Thank you, Eric. All right, Ilan, you said you might have some straight up responses to him here in your 10 minutes.
Yeah, hopefully I won't take 10 minutes, though there are a lot of things you mentioned at the beginning that I also want to respond to. The first thing I'll say is, you know, when I made these remarks, I was thinking that I was conceding in a large respect to Eric, right? Because you can't ignore the fact that the court got it wrong for in many important cases, in many important generations. But I will say that at least they were purporting to be originalists, which itself is some indication, right, that originalism has always been part of the law, and it's not some new thing. They always felt that they had to justify themselves from the perspective of the text and its structure and its history and the framer's intent, to the extent that that might be relevant to understanding the text and so on. And why? It wasn't until the 30s, 40s, 50s, 60s where they kind of started abandoning that. My point here is only to say, although the court in certain cases has certainly acted like living constitutionalists, at least since 1857, okay, in many cases it wasn't. And it was always purporting to at least be originalist. So originalism isn't this new thing. Originalism wasn't invented in the 80s. Maybe Eric's point is originalism has been tried since 1857, is proven to be impossible. Okay, fine. You know, maybe that's the argument. But it's certainly not true that originalism is new. I don't think Eric's making that point, but certainly that's how it's often, perceived. So I want to say that. Look, on the whole, vague and aspirational parts of the Constitution, I don't think the Constitution is full of vague and aspirational clauses. I just think that's wrong on the merits. Now, I don't want to relitigate these merits because Eric and I litigated it last year on my book, The Second Founding. But I think the necessary and proper clause, I think the 9th Amendment, I think the privileges or immunities clause, I think due process, I think protection of the laws are relatively ascertainable and relatively clear legal concepts with clear legal meanings. And yeah, of course, they can apply to new and changing circumstances, but that doesn't mean their meaning has evolved. So their meaning is both specific and their meaning doesn't evolve, okay? And if I'm right, one point about this that I like to make, everyone says, oh yeah, the Constitution has majestic generalities, which I think was Cardozo's words, or glittering generalities. First of all, that term, glittering generalities, was used as an attack on people who wanted to say the 14th Amendment doesn't mean anything. So they were debating I think it was the Force Act of 1871, or maybe it was one of the Reconstruction Acts in the early 1870s. And someone said, if this 14th Amendment not be full of mere glittering generalities, it must actually allow us to do X, Y, and Z, right? Glittering generalities, I admit, if that's what it does, then it doesn't help us a lot. But the framers of the 14th Amendment did not think these were glittering generalities. They thought these were specific rules that were tackling specific problems, like the race discrimination and the Black codes, Ku Klux Klan violence and private violence with protection of law, and so on. And obviously the widespread denial of due process to the freed people in the South. These are specific provisions for specific clauses. Okay, let me just say, since I have a few more minutes, I think a lot of the decisions that Eric says are unoriginalist are in fact originalist. And I won't just, I'll get to, I hope, the modern court, but let me start with sovereign immunity, anti-commandeering, dormant commerce clause. I think Eric gets this exactly backward, okay? It's true. There's no sovereign immunity clause in the Constitution giving states sovereign immunity. But that's not how the Constitution works. The Constitution is a grant of power to the federal government, okay? The Constitution was enacted atop, as Jonathan Gnapp says, and as Eric Siegel says, existing law, existing custom. And under the existing law, okay, states had this thing called sovereign immunity. Therefore, the question becomes, did the Constitution give Congress any power to abrogate that sovereign immunity? That's the question. It's a question of whether Congress has a granted power to do it, not whether the states have it. The Constitution doesn't say whether the states have it. The Constitution doesn't speak about a lot of things, because a lot of things pre-exist the Constitution. This was there, like free Black citizenship. The Constitution takes it as it found it, intact in the states. Okay, go through Article 1, Section 8. What in the Constitution gives Congress the power to abrogate sovereign immunity? Certainly nothing express, so it would have to be the necessary and proper clause, but the necessary and proper clause is a grant of incidental or implied powers. It can't be this great and substantive powers, right? What's the distinction? If Congress hadn't been given, specifically enumerated, the power to tax, the power to declare war, could you have implied the power to tax and the power to declare war through the necessary and proper clause? No, of course not. Some things are too important to be left to mere implication, which, by the way, is some support for our major questions doctrine as a matter of legislative intent and statutory interpretation. The question then becomes whether abrogating sovereign immunity or commandeering a state's officers, okay, is incidental and implied, or is something too great and important that we would expect to be left to implication. We can disagree on the merits of that question, but the point is there is a sound textual basis for that question. I have a whole argument in the University of Chicago Law Review about why there's actually a lot of originalist evidence for a dormant commerce clause. I'm not going to fight with Eric about that specifically, because most originalists agree with him. And there's a case today, the pork producer case, and Justice Gorsuch, said, I don't think there's any support for this. That was Scalia and Thomas's view for a long time. But I think more and more originalists are coming around to the position that the grant of power of commerce, the grant of a interstate commerce part of Congress, was exclusive in its nature. What do I mean by that? It's exclusive and comprehensive. What Congress chooses to leave unregulated is part of its system of commerce. And so it doesn't, of course, if Congress just passed a law that said, only all regulations of commerce are valid, everything else shall be unrestrained. It could do that, and then we'd have the dormant commerce clause anyway, just through a statute, right? Well, they didn't think you needed that, because in its nature, the grant of commerce gave Congress the power over the whole field. So I think that's supported. Women's rights. Okay, how does this work? You know what? How much time do I have, Judge? Tell me before I show up.
You go ahead. I'll go. Let's take 5 minutes. 5 minutes. That'll give us 20 minutes for Q&A, if that's
okay. Sure. No. So cut me off, though. Seriously, I have an oral argument tomorrow, so I've got to practice keeping things in time. Okay. Well, the privileges or immunities clause, if it means what I said it means earlier, right? That you can regulate the content of rights, but you can't abridge them. How would this work in the context of women's rights? Well, something we know about the privileges and immunities of citizenship, okay, is that it refers to civil rights, the kind of fundamental rights that pre-exist civil political society, that all free governments have to secure: contract rights, property rights, and things like that. Those are among the privileges and immunities of citizens. But political rights like voting and holding office and sitting on juries are not all citizens have voting rights. Okay, political rights are reserved to the highest echelon of society. Okay, originally just white male landowners, universal white male suffrage, then male suffrage, and eventually we bring women in too. Okay, well, how does this work? Well, if and by the way, how do we know this is true, that other than they all said so? Otherwise, why would we need the 15th Amendment? Why would we need the 19th Amendment granting the right to vote if it was among the privileges or immunities included in the 14th Amendment? Okay, well, maybe Bradwell was rightly decided in 1873. I don't think so, but maybe it was. Maybe Illinois could tell women they can't be lawyers because of the law of coverture. They can't enter into their own contracts with their husbands. Fine, maybe. Okay. But in 1920, 1921 to 23, okay, there have been two changes. One, coverture laws have gone away in a lot of the states, and women could, in fact, enter into their own contracts, and women were granted political rights. They are now part of the highest form of citizens. They are on the highest echelon of citizenship. Well, if they have political rights, all of a sudden it becomes arbitrary to discriminate in the provision of civil rights, to treat them differently than men in the provision of civil rights. You know who made this argument? The arch conservative, one of the four horsemen of the New Deal apocalypse, George Sutherland, Justice Sutherland, in dissent in the notorious and spooky, since it's Halloween, Adkins v. Children's Hospital case, striking down a minimum wage law for women. It's understood as a Slockner era interfering with the legislature's right to be paternalistic to women. Okay, turns out the Lochner era wasn't all that bad. What did Sutherland say? He said, now that women have been fully brought into the regime through the 19th Amendment, and it becomes arbitrary to discriminate in their civil rights. What men could do, women could do. And therefore, if there's no minimum wage law for men, there's no minimum wage law for women. Okay. And so it makes sense. So sex discrimination actually works under the Privileges or Immunities Clause. Last point about affirmative action, and then I promise I'll stop. It's true that the evidence here is mixed, but I think a lot of the evidence of affirmative action in the Reconstruction period is actually explicable on other bases, right? So a lot of it is actually affirmative action toward the freed people. And this, I think, is enforcement legislation under the 13th Amendment, enforcing abolition, enforcing a condition of freedom, direct reparations, right? 40 acres and a mule to those who had been enslaved. There are laws, for example, that brought Black persons up to par with white persons. So there's a law that's often cited for the relief of destitute colored women in the District of Columbia. Okay, well, there was relief laws for white women in the District of Columbia, right? So a lot of these things look like affirmative action, and they were sort of just actually brought up to par with existing laws for white persons. And then this is not an argument I like to rely on, but the 14th Amendment doesn't bind the federal government. So that could also be an explanation in a way for why this makes Bowling v. Sharp potentially problematic. So I don't like to go too far into that, right? But there are explanations for that evidence. I still don't know what I think fully about affirmative action under the Privileges or Immunities Clause, but if the court does find it's colorblind, there's plenty of evidence for that. It wouldn't be totally out of left field. Okay, with that, I'll stop. There's so much more I could say about Bruin and Establishment Clause, but that's at this point, Eric and I are just arguing lower order merits, right? Disagreements.
Sorry, Judge. No, we're not, because what Ilan did not respond to tonight and hasn't in the last two debates is my meta point that if one is an originalist, if one is a true originalist, judicial review has to be limited to clear errors. Notice he didn't mention that. And if judicial review is limited to clear errors, then virtually every case the Supreme Court has ever struck down a law is incorrectly decided.
So the only thing I'll say about that, and I have responded before, I don't know if you found it persuasive, but I don't read Madison I don't read Hamilton the same way, right? Irreconcilable variance. Yeah, you have to decide that it's irreconcilable. It's kind of like the rule of the classical rule of constitutional avoidance, where if you could construe a statute to be consistent with the Constitution, then you would uphold it. But sometimes it's irreconcilable variance. A law is just unconstitutional. I don't think that phrase means it has to be clearly unconstitutional beyond doubt, that no reason.
What does irreconcilable mean to you?
It means the statute with the meaning X and the Constitution meaning Y. Y says not X. You can't do X. That's irreconcilable. Whether it says
exactly.
Patently, or you deduce it through structure, it doesn't actually tell us. It doesn't tell us that.
Well, let me jump in here and just ask a question about this, and then I do want to get to these other questions because we've got some great questions that I think go to the heart. But is there sort of a structural to your point, Ilan, because we have a Supreme Court that doesn't have to hear, it has discretion over its docket. And one of the big things that you're taught, and seems to be the case, is that here's cases where the circuits disagree, where presumably those are the hard questions, right? And so there is sort of the argument, at least, that the Supreme Court only takes cases that are the hard questions, where and you think there's a inconsistency between that and the idea that those are the cases that would present an irreconcilable variance. And so what about the idea that, yeah, maybe the work that I do, I get lots of easy cases, but those don't go to the Supreme Court.
Yeah, I think that's a problem if you think Eric is right. If you think Eric is right, that it has to be clear and it can, no reasonable person could disagree. I mean, I don't even know what clear means, right? Because I know people who've argued crazy stuff, okay, about the Constitution. Does that make it not clear, right? It is a 7-2 decision. If 7 justices are pretty sure it means X and 2 say it doesn't mean X, is that unclear? 8-1. I mean, if it's 99% of the evidence points to one way and 1% to the other. I mean, how do you know? Okay, what's this threshold for clarity? What's this threshold for ambiguity?
I can answer that.
A very difficult question. And my answer to that question, okay, is the judicial duty is in a particular case in controversy to decide, the judge has to decide what he or she thinks the law is and apply that law in that case, refuse to give effect to an irreconcilable variance in the statute, right? If the statute is an irreconcilable variance with what the judge decides that the law is in the judge's judgment, okay? And that's how judges work. Sometimes you get disagreement, sometimes you get dissents, but that's what they have to do because there's no way to answer the question of 51, 49, or what if it's 55%, 45? At what point do we say, I'm confident enough? I think you just have to decide, I think this is the answer based on all the evidence. And I'm not a judicial supremacist, I'm a departmentalist. I believe judges only bind the parties before them, and this minimizes some of the damage in a way.
So,
I think that's what Lincoln believed.
If I may,
Well, Eric, let me jump, because I have a question. I think that's kind of related to this. And we've only got about 10 minutes, and I feel like a good question that's come from our audience for each of you. And I kind of, I think it kind of pushes on what both of you are saying in a way that I'm curious to hear the answer to. So I'll start with Ilan. I think I'll start with the question about him, and I'll just read it here, and I might add my own little thing. But it says, Professor Wurman, one of your central claims is that originalism, at the very least, provides a standard of correctness. And how do you respond to Professor Siegel's claim that this standard is rarely, if ever, adhered to in practice? And I might amend that question to say, yeah, your answer might be no, it's often adhered to, but how about that it's rarely, if ever, adhered to in the big cases that matter, which I think is what we heard Eric say earlier, which are the ones that we care about, right? And so, how do you respond to that claim? And I would just add to that one criticism that could be made of your position, because I think you mentioned several times tonight, you talked about the prejudices that are time, and one takeaway somebody could take from your comments is, yeah, we can use originalism when we're not living in that time to look back and say, oh yeah, they got that wrong because those poor justices were stuck with the prejudices of their time. But if that's what originalism is good for, is giving historians and academics the ability to criticize the decisions of the past, how is it that helpful? I mean, can originalism, as a practical matter, break us out of our own prejudices of our time, to use your words?
No, and I'll happily give Eric the last word on all of this. I know since I've gone on a bit now, but no, we can never fully escape the prejudices of our own time. One of the lessons here is that Eric is right, and I think I met him most of the way there. Actually, is that there's a real risk, whatever methodology you use. Okay, whatever methodology. I mean, look, conservative living constitutionalism, which some say is what Sam Alito is, right? Which I don't, okay. You can't escape the prejudices there, okay? With originalism, at least some of the time, okay, you have the conservative justices joining the liberal justices in various decisions. Every single one, okay, of the last 20, 30 years of a so-called originalist justice has joined the liberals, okay, in some case to break the conservative bloc, together, okay? Other than Justice Kagan, who occasionally jumped ship. This almost never happens with the liberals. They almost always vote as a bloc. They almost always vote as a bloc, which I think suggests that they're the ones more stuck to their particular prejudices. Now, look, we all have prejudices. We all have to understand that we see life through that way, through that lens, and we have to do our best to overcome it. And that's what historical work wouldn't be possible if it were totally impossible to overcome those prejudices. We just have to recognize that they exist and do our best to overcome them, recognizing that we may not be fully overcoming them, but we're doing our best, right? We can't let the perfect be the enemy of the good.
Judge, before you ask me your question, I have to
No,
make
yeah,
a
Eric, I
correction.
want to hear your thoughts on this.
Well, what Ilan just said is just wrong. Alito and Thomas have almost never, if ever, voted with Thomas did one time in a free speech case. They've almost never voted with the liberals in a 5-4 case. It is true that O'Connor and Kennedy did all the time. They both disclaimed originalism their entire careers. Justice Kennedy said over and over again in Lawrence versus Texas, in Casey, in Romer, that each generation must, for its own sake, all the magic words that he used. So it is simply not true. Alito and Thomas never joined the 5-4 cases. Maybe Thomas once. He is right that justices like Ginsburg, Sotomayor, almost never, if ever, joined the conservatives in a 5-4 case. That's because ideology governs everybody. And the reason why Justice White, a liberal appointed by Kennedy, turned into a moderate/conservative, White, Blackmun, Stevens, O'Connor, Kennedy, all had moderate politics. So guess what? They voted moderately. Ginsburg and Sotomayor and Justice Marshall all had really liberal politics, so they always voted liberal. Alito and Thomas have really conservative politics, so they always vote conservative. So all of that just goes to show that it is ideology, not text, history, tradition, precedent that governs Supreme Court decisions. The last point I want to make before your question, Your Honor, is appellate judges in the United States of America are not supposed to overturn district court findings unless they are clearly erroneous. And although there are some cases on the line, obviously, sometimes it's going to be close whether it's clearly erroneous or not, like 98% of the time, appellate judges affirm the factual findings of district court judges for many reasons, one of which is it's very hard to write an opinion that a factual finding is really clearly erroneous on a cold record, without hearing the testimony. That clearly erroneous standard works. In fact, I have never heard anybody complain that the clearly erroneous standard doesn't work. Some judges get it wrong. Judges are human, but it works. We could have they thought we were going to have a clearly erroneous type standard. That's what irreconcilable variance means. That's what manifest tenor means. That's what the state court judges who were wrestling with judicial review before our Constitution was ratified, who had the authority to strike down laws under state charters, that's what they thought it meant. We have to make a finding that this law is absolutely, completely inconsistent with our state charter. So a clearly erroneous standard for judicial review for constitutional cases could work, just as it works for appellate judges reviewing facts of the district courts.
No, thank you, Eric. Okay, so I think this a couple of things. I think my question is sort of the next question, which I'm going to try to put together two questions here to ask you. We'll build kind of along the same line, and it's also going to be a compound question, which is completely unfair, but you might want to write down a pen. But I think they're questions that relate to each other, and I'm very curious as to what your answer to them is. So the first question is, it seems like, basically you're saying there's an interesting disconnect in that. I think you would agree with this. If we take as a given what you're saying is true, Eric, we also have this odd phenomenon that's going on that in recent times, especially, you see more and more people embracing the concept of textualism or originalism. I think I was actually there when then Dean Kagan, now Justice Kagan, said we're all textualists or originalists now at some Federalist Society. Now, she might have been joking, but you would never see somebody at a Supreme Court confirmation saying I'm a living constitutionalist. You just wouldn't see that, right? And you would even see judges that aren't Scalia's saying that they are more originalist textualists. So why?
Judge, you're coming in and out. I'm really sorry.
So the first question is, why, in your view, and maybe you disagree with me on this, but why do we have this disconnect between, you're saying it's all living constitutionalism, and yet nobody seems to want to embrace that. So why that disconnect? And then the second question, which we're getting from in a couple of different ways, is okay. So that's fine. The criticism, you make a very good case, a very interesting case for the. But what do you? And obviously we don't have a lot of time. So, but what would you say should be done instead of what's currently being done? I mean, it's pretty clear to me that that having a judge say, "I promise to be an originalist," is as they go on the Supreme Court is not going to work in your view. So, what is there anything, or do we just throw up our hands? And then, of course, Ilan, I want to hear any thoughts you have in response there.
Thank you, Judge. Well, first of all, Justice Brennan, Justice Holmes, Richard Posner, there are a lot of very smart people who have explicitly disclaimed originalism. I mean, now, as far as recent times go, I would suggest, I wish every single member of the Federalist Society in the United States would read an article by Jamal Green, law professor at Columbia, called "The Selling of Originalism." And that's what happened. "The Selling of Originalism" is the name of the article. The fact is that it's become a talking point. It's become a soundbite to say, "I'm an originalist." By the way, Justice Kagan recently said that when I said that, I guess I was wrong, or something to that effect. But she never said it. What Justice Kagan said about originalism, to be very clear, was we're all originalists in the sense that where they lay down specific rules, we follow them. But where they lay down vague principles, then we have to do something else. That's what she said. By the way, that's what Randy Barnett believes. That's what a lot of originalists believe. That was her entire quote. So that, and I wrote a whole article about Jack Balkin and her misusing, Balkin's book, Living Originalism, tells you everything you need to know about that. All she meant was where the Constitution is clear, we follow it. I conceded that in the first minute of my talk. Wyoming gets the same number of senators as California because the Constitution is clear. Those cases don't get litigated. My proposal is the same that it's been for a very long time. I would like to see Chuck Schumer and Mitch McConnell hold a national press conference, shake hands, raise their hands in unison, and say, from Dred Scott to the legal tender cases, to the civil rights cases, to Lochner plus 200, to Roe, to Heller, all the way down, we're tired of the Supreme Court playing such a large role in our country, in our politics, and in our elections, which it has done forever. Here's our solution. We're going to have an even number of Republicans and Democrats on the Supreme Court of the United States. There is no number in the Constitution. It was originally 6, for those who care. So an even number is certainly originally possible. And what that means is, in every case ever decided by the Supreme Court, one Republican would have to agree with the Democrats, or one Democrat would have to agree with the Republicans. Eventually, we'll filter down that requirement to the courts of appeals as well. And Justice Kagan, writing in 2017, when 2016 was that court, 4 Republicans, 4 Democrats, in the wake of Scalia's death. Justice Kennedy, the most liberal Republican, was more conservative than Justice Breyer, the most conservative Democrat. She said, we compromised more, we talked more, we issued more narrow decisions, we were more modest. All the things that Hamilton said to Brutus would happen and didn't happen, happened in 2018. It is a nonpartisan or bipartisan solution. I understand today it hurts Republicans, I get that, but there'll come a day when it doesn't. There'll come a day when we're all flipped. So for the rest of time, we have an equally divided Supreme Court, which means that's how I implement the clearly erroneous or the irreconcilable variance standard. And for those of you out there thinking that just makes the 2-party system more ingrained, I would suggest we haven't had independent justice in a very long time. We're not going to have one in the near future. But if we do, I have an entire statutory mechanism I wrote in the Pepperdine Law Review to affirm an independent if that's what the parties want. But that proposal does not require a constitutional amendment, does not do that. It is bipartisan, nonpartisan, and would dramatically weaken the power of the United States Supreme Court.
Interesting. All right. Well, we got about Ilan, you got anything you want to say for a couple minutes here? And we're about ready to wrap up.
Yeah, I mean, just in a nutshell, I mean, I do have some proposals, but very different. To answer the question that I guess it's Bryce, or I can't remember who asked, but that I didn't answer fully. I do think, I just want to go back to the point that originalism has answered more questions than Eric has led on. And I do think that originalism does not always predictably lead to conservative results. And I think Thomas is a good example of that. I do think he's, whether it's joining Scalia and others on the confrontation clause where they joined the liberals, whether it's Thomas on administrative patent judges, on export-import clause, there are all sorts of cases where originalism sometimes leads them to join the liberals.
The
The
export-import clause,
Well,
really?
it's sort of dormant commerce clause case, and there are other examples, but the problem with with Eric's proposal is if the 3 liberal justices never broke ranks to join the conservatives, how are 6 and 6 or 3 and 3? You know, it's always going to be Republican joining the Democrats because the Republicans are going to believe in this thing called originalism.
Justice White did all the time, Ilan.
Yeah, well,
Justice White joined the conservatives all the time.
Okay, so maybe one exception, okay, and you know
Justice Breyer has joined the conservatives in
I don't
many
think-
criminal cases.
I don't think
Breyer
Justice
has joined-
White, you know, I mean, was it particularly? Yeah, he was more conservative. Just that's who he was. He was
Breyer joined the
Democrat, but,
conservatives.
you know, yeah, but Brennan and who's the other? Earl Warren were appointed by a Republican. You know, it's like, so that's not the standard. I don't trust that. Okay, I don't trust that. I think as a factual historical matter, you look at all the Republican appointed or just actual conservatives, they always join the liberals more. Why? Because they have a standard that doesn't just depend on their ideology. And that goes back to the whole debate that I know you disagree with. What I will say is I'll end with a pitch. There are other ways to kind of reform and improve the Supreme Court. And so I'll give a pitch to the National Constitution Center, which did a constitutional drafting project where they commissioned 3 teams of 3, a progressive team, a libertarian, and a conservative team. And then they got us together in a constitutional convention where on areas where we agreed, and we actually proposed, this was a month ago, 5 amendments to the Constitution, including one that would reform appointments and confirmation process. We would make 18 years staggered term limits to the Supreme Court, but it's not enough. You'd have to reform the confirmation process, right? Because if an 18-year term expired, but the Senate and the presidency were in other hands, right? How would you guarantee that an appointment is made? So we make confirmations automatic. All confirmations for executive and judicial offices are automatically confirmed within 3 months, unless the Senate sooner calls for a vote and disapproves, or they can sooner call for approval. These are online. I think those would be great changes. And this goes back to Eric's very first point, that the Constitution is impossible to amend. It's very hard to amend. It's true. It's been done before. And when's the last time you got libertarian, conservative, and progressive law professors to agree on anything? We have 5 amendments. I recommend you check it out. And I think it will resolve a lot of these issues too.
All right, well, thank you both. And
Sorry
Let me
for
just
having
say-
the last word, Eric.
yeah, let me just say, Eric might get the last word, but he's going to be, I believe, at the National Convention in a couple of weeks on a panel. So he can, hopefully he'll talk about whatever the topic is on that panel and not just respond to Ilan here, but maybe he'll slip something in. I don't know, Ilan, are you going to be there at the National Convention also?
Not this year.
And
no.
I will be there on a different panel. And so please join us there. And then I think I'm going to go ahead. Eric, I'll give you 20 seconds.
Okay, let's end on a harmonious note. Thank you, Ilan, for agreeing that life tenure needs to be abolished. I think this is an obvious and easy thing. It was not true 15 years ago. The conservatives and originalists believe that. I think most do today. If we can all agree on one thing, it is this golden rule, Judge. I'll end with the golden rule. Never, ever in a democracy give a government official largely unreviewable power for life.
Well, I agree with that generally. I'm just not sure I agree with wanting to give up my sweet, cushy job right
You're
now.
okay for a while. Lower court judges can
Your
have it.
grandfathered in, Judge.
Yeah.
All right. Well, thank you both. I'm going to turn this over to Leon to close us out. And again, it was amazing. Thank you both.
Thank you, Judge Vandyke. In closing, I would like to thank both of our fighters for this evening's Feddie Night Frights, Professor Siegel and Professor Wurman, as well as our referee. We really appreciate your insights and for a fascinating, very lively discussion that we heard this evening. To our audience, thank you all for joining us at this Feddie Night Frights. Be well, have a great night, and happy Halloween.